Hello, this is Attorney Mike Gravelin coming to you from Chicago. As usual, we've got a fun one tonight. I caught a little bit of Judge Manning. I think she's still going right now, actually. But this was from earlier. Oh, yes. Oh, yes, indeed. I have Judge Manning singing Outcast. Just a skosh. Just a little bit of Outcast. But a little bit of Judge Manning singing Outcast is still awesome. It's still awesome. I also have a very touching moment in Judge Simpson's courtroom, and Attorney Gallagher's last court appearance was today in his courtroom, and he gives him a nice send off. So who was it? Nigel pointed that out to me in Discord or something. I don't know. But they're both a lot of fun. And of course we've also got Little Debbie, the Screaming Goat. I think we're prepared. Let's do this thing.
Mr. Pennington?
Yes, Your Honor. Given the time the defendants spent in jail and the nature of the charges, the state would not oppose the UJR pretrial for the misdemeanors. The state would ask for a bond to remain on the felony charge.
Ms. Jackson? We are going back to in-person reporting.
No, we haven't, Your Honor.
All right, so position 5, we were talking about that before we started. What are we going to do there?
So, Your Honor, the defense would have a motion in this case. I understand, Your Honor, may already have an idea of what's going on, but the defense would move to dismiss this case for warrant of prosecution, this being the second time the officer has been unable to appear for court. I understand that both times there have been a reason. I believe the first time he was on pre-approved leave, and now this time there's a conflicting subpoena. There are other officers involved in this case who could have been subpoenaed. My client has been in custody for over 100 days at this point, waiting for this court date. He's already been reset once, told that we're going to give the state another chance to get an officer here. This is the another chance. There's still no officer here. So I'm asking the court to dismiss, allow my client to be released.
Your Honor, the officer has a conflicting subpoena in this case. The state submits that's a valid reason for this case to be reset. We do understand that this defendant, though, has been in custody for over 90 days, and that reconsidering the bond would be appropriate in this case. So the state's prepared to go forward with a bond hearing.
This is true. He was down in Jackson?
Yes.
Jackson,
Georgia.
Yeah, Jackson, Georgia for probation revocation hearing, Mr. Lane.
And again, Your Honor, I completely understand that. It's the argument that because this is the second time, even if there is a legal reason, what happens when next time there's also a legal reason, and all of a sudden Mr. Dunges has been sitting here for 5, 6, 7 different court dates waiting to get in front of a judge because the officer keeps having some kind of reason why he can't be here.
All right, well, since he's there, he said it was 9 o'clock this morning, but I guess that still takes a few minutes to get here. So we'll just have to make this I don't know, can we special set this that'll trump anything else he may have?
The state will advise the officer.
She's going to deny this motion to dismiss, but she doesn't disagree with it. She's like, yeah, you got a damn fine point. I don't want to cut this guy loose right now, but I understand what you're saying.
Sir, I'll personally call the officer and let him know that whatever reset date we have.
Yeah, because I don't know. I think this hearing would have trumped. Was it a state court hearing that he's in?
It's a probation revocation hearing. I don't.
All right. Yeah. You need to talk to him. This will be the absolute last reset. He's got to get here. If he has to appear by Zoom because he's somewhere else, he's got to make, like when I was a cop, if you were going to make the case, you need to show up at all the hearings. But that was a few days ago.
Yes. I would say, Your Honor, just for clarification, the calendars say that testifying witnesses will need to appear in court. If it is possible in the future for testifying witnesses to appear on Zoom,
I'll usually look at it by a case-to-case
Okay.
basis. Office policy is to not allow witnesses to, but in this case, if it gets Mr. Dungy's day in court, we'd
Okay, well, that's something the state will take into consideration for in the
for this
future.
officer specifically, if we can get him over Zoom, we'll allow it over Zoom
Okay.
just to get
Thank
it
you.
done.
Thank you.
Right. I mean, for him, I mean, you can have him here. He can appear by, I mean, things happen. Life happens. So if there's one officer that has to appear by Zoom, that's fine. Like if there's a lawyer that's somewhere else that has to appear by, as long as they don't appear in their car driving.
Or try to get gas in Fulton County. I knew people would ask, so I threw a link to the Screaming Goat in the description if you're interested.
Before we have the bond hearing, I just wanted to ask pretrial if this defendant is eligible for pretrial.
Pretrial is position 522 CP 212020 eligible for a pretrial release.
I'm not seeing any felony convictions, but I will double check. Let me go ahead and give you the history and see what that recommendation was, Your Honor.
Okay.
The defendant does have 8 cycles. The last arrest was October the 3rd, 2020 in Coweta County, Georgia, for driving while license suspended or revoked. The defendant does appear to have an outstanding hold out of Noonan, Georgia, for a failure to appear. The date on that warrant was March the 8th, 2022. I do see where the defendant did receive a misdemeanor sentence, a nolo contendory sentence in 2021 for driving while license suspended or revoked. And if you hold for just a moment, let me just check and see what our recommendation was for him, please.
Somebody clip that for me. I've been looking for that.
Your Honor, could I also just make a request? If we're going to do his bond hearing now, can we bring him out?
Sure. Yeah, absolutely. You can bring out position 5.
Absolutely.
Okay, he was not recommended because of the outstanding hold that I just announced, Your Honor.
Okay.
It's your courtroom. Nothing in addition.
I got you.
Do we know what the underlying was for that outstanding hold? Let's see.
Do we know what that charge is for that hold?
It's not listed in the GCIC, Your Honor.
Oh, okay.
And I don't have any additional information.
All right. So this is 22 CP 212022. Jason, I think it's Donjees. It is.
We have a problem with the cop showing up again, and Judge Manning is not happy about it. She's nice, but she's not happy about it, which was ironic to me because I happen to have a deposition with a Chicago police officer today, and he showed up, and we had a nice deposition.
What is it? Let's see. 104 days without indictment. You got BGCSA possession of Schedule 1 or 2, attempting to misrepresent a tag, no insurance, driving with suspended or revoked license, knowingly driving a motor vehicle suspended, canceled, or revoked registration. There's a $3,500 good bond as of, I think, the 29th. Wow. You do that for the, so his client can hear that?
It's immature. I know it is.
Is this for the same one that we just read off, Your Honor?
Yes, ma'am, but he's in here now.
Okay. The defendant has 8 cycles. The defendant's last arrest was October the 3rd, 2020 in Coweta County, Georgia for driving while license suspended or revoked. The defendant does appear to have an outstanding hold in Noonan, Georgia, for a failure to appear. The date on that warrant is March the 8th, 2022. The defendant does have one misdemeanor sentence. That was in 2021. The defendant received a no low contendere sentence for driving while license suspended or revoked. Nothing in addition, Your Honor.
All right. Go ahead on a bond argument. And that bond was set, September the 3rd.
Correct, Your Honor. Mr. Denias is 44 years old. He's originally from Atlanta. He will live at the Sharpsburg address that I believe is not indicated on his booking report. So that address is 30277. He lives there with his father and stepmother. He does not have any children. He is a high school graduate. He's a United States Navy veteran, having served from 2000 to 2022. He's currently, wasn't unemployed at the time of his arrest. Hopefully we'll be able to find him something in the future. I do have a note here saying that we believe that Coweta hold is a drug-related case, but I don't have any additional information on it. Looking at the bond that's currently set, it's $3,500, as Your Honor stated. He's had that bond for 3 months and been unable to afford it. Based on that reason, I am asking the court to consider setting UJRs across this case at pretrial, even if Your Honor wants to make it level 3 for the intensive reporting. Just releasing him on pretrial. Otherwise, I would ask the court to hold the felony count where it is and make all other counts UJRs, which I believe would lower the total bond to $1,500, which would be easier for me to get a program to pay or for Mr. Denias to pay himself.
Mr. Pennington?
Yes, Your Honor, given the time the defendants spent in jail and the nature of the charges, the state would not oppose the UJR pretrial for the misdemeanors. The state would ask for a bond to remain on the felony charge.
Ms. Jackson? We are going back to in-person reporting.
No, we haven't, Your Honor.
All right. Let's see. Let me get this right. Okay, here we go.
Don't worry. We get a little more outcast later.
Let me go back over my conditions here.
It's so charming.
No drugs unless prescribed, no alcohol, no weapons, no driving without a valid license, insurance, registration.
Oh, thank you. England in the house.
So we'll reduce, sorry, I'm trying to pull up the bond order. The misdemeanor, so it's 2, 3, 4, and 5 can go through pretrial level
3.
Level 3. Random drug screens. He can stay out of Fulton County unless he's here for court, see his lawyer, or report to pretrial. Sir, don't go back to Fulton County. Fill up with gas in Coweta County. Drive to court, drive to pretrial, drive to Seamer's Lane. Fill up all the way, not $5. Fill up with the tank full so you don't have to fill up again, okay? You can come back for pretrial. And if
Was that not $5? I can't even do it well. It's good stuff. It's so Judge Manning.
if there's any other, you plan on getting him in sort of classes?
We're going to be working on it, yes, Your Honor.
Okay. And if there's any programs that Mr. Lane gets you into, if they happen to drift over into Fulton County, you can do that. You can have that ankle monitor with a 24-hour curfew except for work, lawyer, court, all of that, and the classes. That'll be paid for by the county. So stay out of Fulton County. And the only reason you can come back is for that. And those are the reasons you can leave your house. Court, lawyer, any kind of medical appointments, addiction appointments, or any program that Mr. Lane gets you into. We'll leave count 1 at $1,500. The other one will be UJR through pretrial level 3. You have to call pretrial within 24 hours of getting out?
Yes, Your Honor.
Okay, within 24 hours of getting out. If not, I'll be seeing you back in here. Best of luck to you.
Your Honor, do we want to have a reset date on this, or do we expect the defendant to bond out?
I would still ask for a reset date.
It's January.
We moved to January 17th.
I just had said,
Okay.
told the court I would let the officer know, well, you know, so I
January-
just want to do that.
Is that 9 a.m.?
Yes.
9 a.m., January the 17th, last date for prelim.
Your Honor, I did not mean to interrupt, but are those charges misdemeanors? That you released them on a signature bond through?
Yeah, does it have to go through misdemeanor pretrial?
Well, Well, it's still pretrial. It's just no level. That's all I'm saying.
Well, still give him random screens.
Okay. That's
Thank
fine.
you.
And do I need to put per judge on here?
Yes.
Please. Thank you.
Sure, and the consent of the state and the defense attorney. Consent of the state, that's important you get on there. That bus gets heavy all by myself.
She's not worried about it.
And when he gets finished, we'll talk about the last ones.
Right. Well, I think, yes.
Oh, because the other,
Well, we have 3 outstanding, but 2 we have no expectations, so.
so Mr. Lang,
Yes, Your Honor.
on the Bradberry case, Mr. Pennington said an officer will be here. I guess it'd be like 20 minutes now. I guess he can reach out to that officer again. And the other 2, nada on Hill and Maltsby. Nothing from any officer.
We have no updates on those. We would just request a reset in both cases. These are both serious cases. So, Your Honor, we would just request this to be reset for another date. We would expect to be able to subpoena the officers and have them appear by then.
It looks like both of them are over 90 days with no bond. Would you at least like to hear a bond hearing? Because this will be, I'll give 1 reset for officers.
Well, Your Honor, just to put on the record, the defense would have a motion in both cases.
ahead.
I'll start with position 7. We would move for a dismissal for warrant of prosecution based on the failure of the officer to appear for court or provide a legal reason as to their absence. We have other officers who called ADA Pennington and provided him with a reason why they're not in court today. This officer is a no-call, no-show. If this case is that important and that, upsetting, I guess, in the nature of the charges or that serious, then the officer should be here to do their diligence on the case. They're not. Based on that, I would ask for dismissal, and that would be the same argument on position 8, understanding Your Honor's, not just discretion. That's the word, discretion.
I know it's getting late. Mr. Pennington, would you like to respond to Mr. Lang's argument?
Yes, Your Honor. The state understands Mr. Lang's argument, but the state also has to consider that there was a victim in this case. So the state does request a reset here. But given the argument that Mr. Lang makes, it would be appropriate for the court to note in this calendar that the officer did not show.
Is it the same officer on both?
No, it's 2 separate officers.
Okay. Well, they've been in 94 days, one without an indictment, and I do believe they're both on no bond status. So, like I said, back in the day, when I was a cop, if you didn't show up and you were subpoenaed, you got 3 days off without pay.
Your Honor, our understanding from talking to APD is that they are, at least with the Atlanta Police Department, is that they are implementing without pay. I think it might be 2 days, but I'm not sure of the details for officers that do not show, and we will let the APD know of any officers that do not show.
Yeah, I mean, it's not fair to these folks that sit in jail. They still have that presumption of innocence, yet they're sitting in jail, and yeah, we can get them on a bond hearing, but they have that right to the prelim, and I don't know. Trust me, I get it. I was a cop. I'd stay up. I'd work all the time, and sometimes I'd fall asleep sitting in the courtroom. But it's not you. But they got to get here. If you're gonna put them in jail, then show up to court. It's simple.
So the judge, I agree with her completely here. She's denying the defense motions, but she agrees with them. I think I feel the exact same way about it. I get it. Colin, yeah, it does happen that police officers don't show up. Ask anyone who's got a traffic ticket about half the time, if not more. If you get a traffic ticket, certainly in Cook County, and you show up, the police won't be there. Sometimes they will, sometimes they won't. You can't bank on it, but it's not unheard of. However, in these more serious cases, you got to get there. That's a little different. Those people aren't sitting in custody.
And I know that I will take you first. If you've been up all night, I'll take you first. Whatever it does, I will make an exception. But yeah, I hope so. If not, I'll talk to Chief Kirschenbaum myself and tell him to get these officers here. I mean, this is insane.
I'll talk to Chief Kirschenbaum myself. I don't know the players involved, but I'm like, I could so see Judge Manning saying, "Get him on the phone." I'm tired of the officers not showing up in my room. I'm tired of it.
Truly insane, but it's not your fault. So we'll do that. One only reset. Ms. Holmes, one reset. Period.
They can't even get gas there.
And those are going to be the 17th also, Ms. Watts? So those will be the 17th also at 9 a.m.?
Thank you, Jeremy.
Both will be at 9 a.m. She's hiding over here under the bench, so you can't hear her because she's way up in front of me, like whispering. So those will be that
Thank
also. And do you just want to go ahead and address bonds on 7 and 8?
Yes, Your Honor, but I do think my clients would need to be present for those.
Yeah, okay, so we'll take Hill, Aisha Hill first. I've had a lot of cases today. I'm losing my voice. All week, it's been a long week. No, but you know, all those calendars and like blah, 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 blah.
All those pre-trials.
Yeah.
Here we go. Sorry, I meant to mute and I paused.
All right, this is position 722 CP 212301 Aisha Hill. Hopefully I pronounced that correctly. One charge of aggravated assault. There's 94 days without indictment and there is no bond as of today. Wow.
The defendant has 13 cycles. The defendant's last arrest was September the 5th, 2017 for a probation violation. The underlying charge was aggravated assault. The defendant does appear to be on probation in Fulton County for aggravated assault. That case number is 15 SC 137519. And that disposition date was February the 8th, 2017, and the term is for 8 years. Also, the defendant appeared to have an outstanding hold out of Truth County, Georgia, for a failure to appear. The date on that warrant is February the 27th, 2018. Nothing in addition, Your Honor.
And Mr. Lane, as of December the 12th, there isn't a sealed order, so I'm assuming that was an eval?
That is correct, Your Honor. That is something we are working on. I did speak with Ms. Cole, who's the attorney of record on this case. We have sought out some services as well with our own office. So at this time, I am still going to be requesting that a bond is set. So that once we get to where we need to get to in this case, we can work on bond. But my client is not going to be able to make any bond at this time. So I'm still asking that one be set just while we have a court date in front of Your Honor at this time.
You know where she'll be living?
Yes, she'll be living at the 257 Bromack Drive address listed on her booking report.
Yeah, Miss Jackson's cool.
And that address,
I get
it.
she'll be living there with her aunt and several of her children.
Okay. Anything else you want to go ahead with some IALA factors?
Yes, Your Honor. She's 44 years old, lives at the address I indicated. She has 7 children and 4 grandchildren. She made it to the 12th grade. At the time of her arrest, she was a full-time grandmother. She was the primary caregiver for all 4 of her grandchildren. However, she had also applied to and was supposed to be starting a position at a kinder care location where she would be working, taking care of children.
Does kinder care frown upon the 13 cycles?
And working in that industry, understanding that her history, understanding what we've heard about Ayala. She's a lifelong resident of Atlanta. All of her family lives here, all of her children, all of her grandchildren, and understanding what Your Honor does about the order that's already, or the sealed order that is already in place. I would ask the court to consider a bond of, on a charge like this, I would ask for $20,000.
All right. Mr. Pennington.
Yes, Your Honor. The state would just like to note that defendant has a criminal history that includes an ag assault here in Fulton County. Additionally, we'd just like to know the nature of this crime. The officer here at the scene found lots of blood. So the victim was bleeding from multiple places. So the nature of this violence here was severe. So the state just asked for a bond that reflects here that the defendant's likely to reoffend and the danger to the community that this defendant poses. And additionally, here in this case, the state would request no further contact with the victim, Kenyetta Young, Kennytta, Young, common spelling. No weapons, an ankle monitor, and a 24-hour curfew, and whatever other conditions the court deems appropriate.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 2763 Metropolitan Parkway. No further contact with Kennyetta or Kenyetta, Kennytta, Young, Young. I think I gave the address of Metropolitan Parkway. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, including any sort of mental health treatment. And you can also let Ms. Cole know that if there's a program that she gets into, we can definitely modify that to suit that. And you will have 48 hours to have that ankle monitor placed on your hold. So, Ms. Holmes, if the Troop County picks her up, she'll have 48 hours to have the ankle monitor placed back on her ankle for here. $30,000 good bond. Best of luck to you, ma'am. Also, did you get your hair cut yesterday?
Every day I got to come to court. I'm tired. Got off 5 o'clock in the morning last night. I just found out I had court today, 10 minutes ago.
I got some clippers at the house. Come by there.
I need an overnight bar.
That's how I made extra money in law school. All they need is their head shaved, so it was real easy.
Your Honor, do we want to do this?
Yes.
Yeah, we'll go ahead and do yours. So we got
That's the officer for Bradberry.
Bradberry, right?
Correct.
Come on up.
Yes. A traction truck almost took me out, but I got it.
Uh-oh. Well, it's raining. People can't drive when it's been raining.
Do you swear affirm the testimony she gives to the court will be the truth, the whole truth, nothing but the truth, so help God?
Yes, ma'am.
All right, wait on him to get out. This will be, and we're gonna address bond on this one too, because it's been 94 days.
Although I will say, Your Honor, if there's not already, this is a case where I anticipate a sealed order.
Okay. Yeah, and if you don't have one, then send me the motion and the order and I'll be glad.
I'm sorry, Judge. Did the officer state his name and spell it?
Oh, yeah. Hold on. Raise your right hand. You swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes, ma'am.
All right. State your name and spell it for the court reporter.
Officer Cunningham. It's going to be Cunningham. I work for the City of Atlanta Police Department, Fulton County.
So there is, as of September, there is no bond on the 2 counts that, wait. Okay, so it said that before there was a battery, but it was dismissed, yet it shows up on here. Was another battery added? Because at first appearance it had, oh no, sorry, it's no bond. All right, so there's no bond on the ones that are left. My bad. All right, Mr. Pennington, this is a 22CP, yeah. 212-296, Damian Jamar Bradberry. There are 3 counts: false imprisonment, abuse, neglect, or exploitation of a disabled elderly person, and battery. Go ahead, Mr. Pennington.
Yes. Good morning, Officer Cunningham. Thanks for making it down here. You mentioned that you're employed with the Atlanta Police Department. How long have you been employed with the Atlanta Police Department?
6 years.
Okay. And In what capacity are you employed with the Atlanta Police Department?
Police officer.
Okay. And were you employed in that capacity on September 12th, 2022?
Yes, sir.
Were you post-certified on that date?
Yes, sir.
Okay. Did you become aware of a Damian Bradberry on that date?
Yes, sir.
How did you become aware of Damian Bradberry?
I was flagged down by concerned citizens saying that the elder man who owns the barbershop on my beat was getting robbed. The people were frantic. Upon my arrival, I went as fast as I could, got to the barbershop. The door was locked. I attempted to make entry. Mr. Bradberry wouldn't let me in. Eventually, he unlocked the door, so I was able to force my way in. And that's when we took him into custody.
Okay. What did you see when you entered?
He was covered in blood. The victim had sustained several injuries due to an assault.
What were the nature of these injuries?
Lacerations to his head. He had been beat on. It was pretty severe.
Okay. And were you able to speak to anyone about this incident?
I spoke to the lady who flagged me down, a couple of witnesses. They pretty much said that they were trying to go to the barbershop, and the guy came to the door and was like, they said that this motherfucker's closed for the day and wouldn't let no one inside and wouldn't let the victim leave.
Okay. Did these witnesses see anything after was it this guy, was that the defendant that said this motherfucker's closed for the day?
Yes.
Okay. So after that was said, did the witnesses see anything else or advise you of any other information?
Hold on, let me refer to my report real quick. Oh yeah, so he did come to the door for the, you was saying report that he did come to the door for the witnesses, and that's when he's told them that it's closed, and he proceeded to shut the door and lock it.
Okay. And how did you determine that you stated that that Damian Bradberry beat on the victim here? What was the victim's name?
The victim's name is going to be Mr. Willie Huey.
Okay. And how did you determine that the defendant had caused the injuries to Mr. Huey?
The statements from the victim and actual physical evidence on the scene.
Okay. What kind of statement did the victim make to you?
He made a couple statements. He had suffered the head injury. He stated that the guy came in there demanding money from him, and he said he wasn't going to give him any money. And that's when he physically assaulted him.
Okay. And Mark, when you say physically assaulted him, did you get any more description of what that physical assault involved?
Hit him in the head.
Okay.
And I want to say he hit him with a bottle, a plastic bottle.
Okay.
Of liquor.
Okay. And you say that he demanded money. Was any money taken from him?
Yes. We found out later that there was actually money taken from him.
Do you know how much?
Let me see. We recovered $56.67 off of this person's.
Okay. And this
money had blood on it.
And this was on the person of?
This was on the suspect, Mr. Bradberry.
Okay. Thank you. Okay. Yeah.
That's really nasty. I didn't see this part.
So do you have a copy of the warrants in this case?
Yes, sir.
Okay. So I just, if you look down to the probable cause section, I just ask you to look to that third paragraph. It's a short paragraph, and just read it and refresh your memory.
The one with Brittany, when I spoke to Brittany Moses?
Correct.
Upon speaking with witness Brittany Moses, she stated that upon her attempting to go into the business, a male covered in blood came to the door and advised her that this motherfucker is closed for today. Moses stated that the male then locked the door and started to punch the victim in the head.
Okay. And are you the one that spoke to Brittany Moses?
Yes, and it was recorded on body cam as well.
Okay. So you also issued a warrant for abuse, neglect, or exploitation of a disabled person
Elderly abuse.
or elderly person.
Yeah.
Yes. How did you come to the conclusion that was an appropriate charge?
I'm ACT certified, and the male is well above the age. He was born in 1950.
Okay.
And he beat on him.
Okay.
I'm certified. The guy's old enough, and he beat on him. Those are the three. I'm sorry. It's a serious. The charge and the situation are serious as can be, but that exchange is fantastic as far as I'm concerned.
Did you get any indication that he targeted that Mr. Bradberry targeted Mr. Huey because of his age?
I can't speak on that.
Okay.
Because I'm not sure if that's what it was.
Okay. Did you get any indication that he knew or should have known what age Mr. Huey was?
From my understanding, they did have history.
Okay. Okay. Thank you. You also issued a warrant for false imprisonment. How did you come to the conclusion to issue that warrant?
By him locking the victim inside of the business and not allowing him to leave. And when I got on scene, he wouldn't allow the victim to leave.
Okay. Okay. Thank you. Did you get an indication that the victim wanted to leave or attempted to leave or?
Yes, the victim was very frantic. I mean, he had suffered several injuries from Mr. Bradberry.
Okay, thank you. And this location, do you have the address for this location?
Yes, it's going to be, let me grab it. $782 Cameron M. Alexander Boulevard.
Okay. And is that in Fulton County?
It is in Fulton County.
Okay. And do you see Mr. Damian Bradberry in court today? You can stand up if you need to.
I would love that.
Yeah.
Everybody remove the mask?
Yes, that's him. Okay, he's right there with the blue jumper.
Okay. The court note for the record that the witness in this case identified the defendant, Damian Bradberry.
Noted.
Okay. No further questions for this witness, subject to redirect.
Go ahead, Mr. Lang.
Good morning, Officer Cunningham. Good morning. My name is Attorney Lang. I represent Mr. Bradberry today. I'm going to ask you some questions of my own, follow up on some of the questions you were asked by ADA Pennington. Let's start with, so the property that this happened at, what was the nature of the property? Was it a business? Was it a residence? It was a barber shop? Okay. I know you approached via the front entrance, correct? Yes. Are you aware of whether the property had a rear door as well? I'm not aware of the rear door. Were any statements made to you by anyone about a back door or any other way in or out of the property? No. Okay. You said you believed there was a history between Mr. Bradberry and Mr. Huey. Do you happen to know the nature of that history? Not to any extent that would be beneficial to the case. The victim did state some things, but you know, that's beyond me on this case right now. You already kind of alluded to it in direct, but your body-worn camera was on and active the entire time? Yes, sir. Do you know if that video has been recorded to Axon or evidence.com? Yes, sir. Okay. Do you know if the property itself had any surveillance footage? Not from my knowledge. Do you know the current status of the victim? No, sir. Okay. No further questions at this time, Your Honor.
Any redirect?
No, Your Honor. May this, the state has no further witnesses. May this witness be excused.
Your comments, you can be excused. You sure? I can help you with a haircut.
They'll probably go call me tomorrow. I'll get you tomorrow.
That's all right. Stay safe out there.
Yes, man. I appreciate you.
Good to see you again.
Oh, yeah. See you tomorrow.
Good job.
I'm gonna bring some clippers just in case. All right, I help you out. All right, go ahead on argument.
Your Honor, I will submit to the court on the bottom two charges. However, on the false imprisonment charge, I do think there's an issue here with this being a business location. Most business locations have a front and rear door. While the officer was unable to testify to any specific information about the rear entrance to this building, he was also unable to tell us that that entrance was locked and inaccessible to the victim in this case. False imprisonment requires that you prevent the person from leaving in any way. If there is a back door here that was unlocked, while I understand the circumstances that were alleged to in this case, the victim very well could have had a second way out of this building. Therefore, it would not rise to the level of false imprisonment. I understand that we don't have the concrete, yes, there is a back entrance, yes, it was unlocked, but we also don't have information fully providing that the only means of entry in and out of the building was inaccessible to the victim. So for that reason, I'm asking the court for no probable cause on that charge.
All right, Mr. Pennington.
Yes, Your Honor. We had a witness at the scene that came to the location. As I'm responding to the false imprisonment argument that stated that the defendant locked the door when the witness was there. The door was locked, and he stated that the business was closed for the day. These witnesses would have had a chance to help out the defendant potentially, but were not allowed to. This further indicates that the victim was not free to leave. The state submits on the evidence on the other charges. However, the state would like to add a robbery charge here in this case. There was originally a robbery warrant taken out. The robbery warrant was dismissed at first appearance. I don't have the exact, I was not part of that first appearance, but it's presumably because on that it was not listed exactly the property that was taken. The officer has testified to that now, that the money was taken at and the amount of money that was taken from the victim, so that we believe that probable cause exists for a robbery charge in this case, and that given the facts available, that should be added now.
You want to respond while I'm looking at that?
Yes, Your Honor. I would ask the court to hold off on adding that charge at this time. If that's information the state wishes to proceed on, it can be handled at indictment at this time. That charge was initially dismissed at first appearance. I believe the proper remedy would be to re-indict on that charge, but at this time, I'd be asking the court not to add that charge.
Your Honor, when something's dismissed, I just want to respond to that. When something's dismissed at first appearance, this here is a probable cause hearing, so that, it is appropriate to reconsider the probable cause from something heard at first appearance at a probable cause hearing.
Right. I looked at, some of the warrants are defective when they say committed a theft, but they don't say what. So we'll add that. Go ahead with your, wow, I'll find probable cause on all that and add robbery. She just wants me to sing to her again. Are you listening, Miss Jackson? We are for real.
All right. The defendant has 14 cycles. The defendant's last arrest was May the 14th, 2022 in Fulton County for simple battery. That case appeared to be still pending. That case number is 22 MAGCS 2550. Also, the defendant appeared to be on probation in Fulton County for aggravated assault. That case number is 18 SC 161591. That disposition date was December the 19th, 2019, and the term is for 3 years. The defendant appeared to have additional case that may have ran concurrent with that case. It's for aggravated assault as well. That case number is 19 SC 170482. That disposition date is the same, December the 19th, 2019, in the same term, 3 years. The defendant does have a prior felony conviction. Well, actually, it was in 2021 for aggravated assault. with confinement for 8 months. If you like that case number, I can provide the courts with the case number, Your Honor.
Do you want it, Mr. Lakes? I've got it on the,
I'm okay for right now, Your Honor.
we're good.
Okay. Also, the defendant has a history of failure to appears. There were 2 in 2018. Nothing in addition, Your Honor.
All right. Go ahead, Mr. Lang. And it says on here he would be homeless. So
And Your Honor, at this time, I do not have an updated address for the court. This is the case where there are substantial MH and substance abuse issues at play. As I mentioned, Your Honor, earlier, I believe this is a case that a sealed order may be getting filed in. Based on the information I have at this time, the IALA factors I can present to Your Honor. He's 32 years old. He did graduate from high school in 2009. He had a CNA license before he kind of entered the period in his life where he is now with the issues I mentioned and with the housing instability at this time. I'm asking the court to set a bond since he is eligible for a bond, having been in custody for over 90 days. I will leave the dollar amount and the reasonableness of that amount to Your Honor's discretion, understanding that this is a case where no matter what the amount is, I don't believe Mr. Bradberry will have the means of affording that bond. I'm going to focus primarily on getting treatment for the issues I've mentioned, and then we'll readdress bond from there.
all right. Mr. Pennington.
Yes, Your Honor, the state believes this defendant's a risk to reoffend and a danger to the community, a danger to this victim in particular. The state would ask for a no further contact with the victim, Willie Huey, in this case, a 24-hour curfew. I realize this victim's homeless and that may present a problem for an ankle monitor, but this defendant needs to be monitored. Additionally, Your Honor, the state would ask that there be the defendant have no weapons and whatever other conditions the court deems appropriate. The state just asks for a bond and reasonable discretion of the court.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Willie, last name Hughhley. Stay away from 782 Cameron M. Alexander Boulevard. That's Banks Barber and Style Shop. You're going to have an ankle monitor paid for by the Orca Project with a 24-hour curfew, court, lawyer, medical, or any programs that the Public Defender's Office gets you into. So you're going to have to supply an address to get out. You have to supply an address where you're living, and I'm sure Ms. Cole, and then we're going to be working on housing for you, so you'll have an address there to supply. But you have to supply that to the jail upon being released, give it to Ms. Cole. They can supply it to the state, and they can put in an address for you, but we have to know where you're living. And it's important because you got to keep that ankle monitor charged, okay? Zzz. I did that for you. Go ahead. You zzz.
Hold on one moment. Let her finish what she has to say, and then you and I will talk. So let her finish what she has to say.
Just trying to help you out, okay? Because that they're taking notes over there. So we're false imprisonment. We'll make 10 abuse, neglect, 20 battery, 20 robbery, 20, 10, 20, 20, 20. And I don't think there were any holds. I didn't see any.
Not that I saw.
Sorry, Madam Court Reporter didn't want that picked up what he was saying on the record.
No, I can't hear that, what they're saying.
Thank you. Is that it, Mr. Lang?
Yes, Your Honor, we're all
All right. Best of luck to you. Are we getting a reset date on this one? Do you want a reset date for the prelim?
The prelim just happened.
I mean, I'm excused. I was talking about the other one, the next one, I think, where the officer's not here.
Oh, yes. You're talking about position 8?
Yeah, it's 8, yeah.
And we already have a reset date there for January 7th.
So I think we were just going to do a bond hearing on that.
Bond on that? Okay, yeah. Sorry, I did flip the page. 17th. Do we need dates on anything else, or are we good?
Yes, Your Honor.
Excuse me, Judge.
Back to the back, go with her.
That's all, Ms. Hall.
Can I ask the ADA his name so I can put it on position 5 consent bond order?
Yeah, Timothy Pennington, common spelling, P-E.
Yeah.
This is See, Mr. Pennington, this keeps him off my huge night court calendar.
And then the last one we need is Maltsby.
We are all for getting rid of the night court calendar. Like we are on board with that.
Y'all don't like me doing night court.
No, if we could get it done in prelims, that would be fantastic.
Your Honor, it's not that I don't like you doing night courts, that I don't like doing night court.
But we move them quicker.
We do. I mean, it amazes me the number of times we'll have 40-person calendars there and we're done within 45 minutes. We rail through it. It's incredible.
We got it down to a science, but the
still doesn't mean I want to be working after 5.
Yeah, but the private attorneys just take so much longer.
It's just the way she says pretrial.
I've had to tell them what IOLA factors are many times. Like,
well, we don't have Miss Bostic here today. Miss Bostic usually sends me a message letting me know what my word count is for the day.
Bostic.
Send me a message letting me know, hey, you got 100 words today. I know you got 10 cases. So you get 10 words per case. You know, keep it.
She told Rockwell she had 20.
Rockwell, take the 20 just to say hello.
Bless her. She has worked hard from her very first days.
Oh, absolutely. I wish I could be half the lawyer she is.
She has worked it. Do you remember her when she would like just be here, back when they used to just appoint lawyers in the courtroom? Like, we need a lawyer, and they'd be like, he's your client. You're going, what? She picked up a ton of cases like that. All right, this is position 8. 22 CP 212314 Theodore Maltsby MAULT SBY 94 days without indictment. There's no bond on aggravated assault. Rah.
The defendant has 44 cycles. The defendant's last arrest was January the 9th, 2020 with the City of Atlanta Police Department for possession and use of drug-related objects. There was no disposition for that arrest. The defendant does have prior felony convictions. There's one in 2005 out of Ware County for felony obstruction of an officer and robbery, and one in 1993 out of Ware County for burglary and robbery, and one in 1991 out of Ware County for burglary. The defendant does have misdemeanor convictions. So one in 2017 for battery, an additional one in 2017 for obstruction of an officer, and one in 2013 for theft by shoplifting. Nothing in addition, Your Honor.
All right.
Wow, Miss Jackson really does have a soothing voice. I want her to read me bedtime stories.
Right. Go ahead, Mr. Lang.
Yes, Your Honor. Mr. Maltsby is 59 years old. He has lived in Georgia his entire life. He was born in Waycross, Georgia, lived there for the earlier portion of his life, moved to Atlanta recently to try to get a new start after both of his parents passed away and one of his older sisters passed away. He kind of wanted to move to a new city and try to restart life over here. He completed the 11th grade.
As a criminal.
He was working on his GED, but has not yet completed it. He has 2 daughters, both in their 30s. One lives in Valdosta, one lives in Jacksonville. Like I said, he's lived in Atlanta for the last 10 years. About 3 years ago, he did have a medical emergency. He had a stroke, which impacts his speech and memory, and has kind of helped him reestablish contact with his daughters, them helping him through this process at this time. He was working for a restaurant called The Food Shop on Lucky Street. He'd been there for about 2.5 years, kind of doing just general labor around the facility, helping with cleaning, taking out the trash, doing dishes, when needed, helping out the chef at that location. The chef has been a friend of his for about 8 years. We have spoken with him, who confirmed that information, confirmed that Mr. Maltsby has worked for him and will continue working with him. Looking at all of the information presented, while I do understand when you hear from the state, they'll probably give their proffer of the facts in this case. It is worth noting that since the origin of this case, Mr. Maltsby has identified to officers a self-defense argument in this case. It is something we continue to stress in this case, continue to explore. There was a knife recovered on the alleged victim. My client was stabbed and injured during this altercation as well. Based on that information, I am asking the court to set a reasonable bond. We are looking into potential treatment options for a substance abuse issue, but I do not believe there's any issue that would rise to a sealed order or anything to that effect in this case. So I'm asking the court to set a reasonable bond. I would ask the court to consider $10,000, but total, I'd ask the court not to exceed 25.
Is there an address where he'll be living?
The address I have on record is the one on his booking sheet,
An avenue?
18 Wayman Ave. Yep, that's the address I have as of right now.
Again, I don't do criminal law, and maybe this is common, but I found it an odd argument. The victim knifed my guy too. I mean, so what? So lower the bond? It's odd.
Now, I do not know the current status of that housing, to be candid with the court. It will be something we're looking into for maybe a housing program as well, if he is unable to return to that address. But as of right now, I have no reason to believe that he cannot.
Yeah, on the pretrial report, it's Westchester. So,
You mean the addresses?
yeah, on the pretrial report, he gives a Westchester address.
And I'm not sure which of those would be the primary one at this time, Your Honor. I'm also looking at Ms. Cole's notes, but it is something we're looking into about whether there is stable housing at this time. I have no reason to be able to tell the court, no, there is not at this time.
Mr. Pennington.
Yes, Your Honor. In this case, the state is most concerned with the violence shown in this incident that's outlined in the warrant. Not only did a stabbing occur, but this appears, based on the warrant, to have been a rather random crime, which presents a danger not.
Okay, everybody's asking me about the sealed document. I don't know what it means in this particular context exactly, but as general, just sealed means that it's not available to the public and nobody can see it except specified people for court business. So a lot of documents are sealed or someone's mental health condition, something involving a minor, really salacious stuff, that kind of thing, or something that's a secret for some reason.
Not just to this victim in particular, but to a danger to the community as a whole. Additionally, would note while the defense did note that they will have a argument about self-defense. The officers at the scene also assessed that and were able to watch video, according to the warrant, which based their determination of a aggravated assault being perpetrated by the defendant based on video which showed the actual assault. So the state just requests a bond which reflects the danger to the community here. Additionally, the state would request no further contact with the victim in this case, no weapons, an ankle monitor with a 24-hour curfew, whatever other conditions the court deems appropriate. That's all, Your Honor.
Any follow-up?
Just with regards to the argument about the video, Your Honor, one of the key elements I was going to question the officer about during the preliminary hearing, had they appeared, was whether or not my client was exhibiting a stab wound in his chest when he appears on that video footage, because at that time he had already been stabbed in the chest with a box cutter by the alleged victim in this case.
I got you. All right. No drugs, no alcohol, no weapons. Stay away from, there's a couple addresses here, 135 Andrew Young International Boulevard, and also 120 Ted Turner Drive. And looks like one of these are close to us. So all Waffle House restaurants. Heartbreaking. Don't go around any more Waffle House restaurants, sir. No further.
Oh, it's our first Waffle House ban. We've had Chick-fil-A, and Wawa, but now Waffle House. I think it's specific to this guy, though.
Contact with Oscar Johnson. You have an ankle monitor paid by that Orca project with the 24-hour curfew except for court, lawyer, medical, or any programs that Ms. Cole / although it's Mr. Lang today, your attorney gets you into. And sir, no weapons is a knife, a hammer, things like that. And if you can make it into a weapon, it's a weapon. Be used as a weapon, so you can't have weapons. You can't carry around a knife, all right?
That's pretty much everything.
$30,000 good bond. You must supply your address before you release of where you're going to be staying, okay? Let them know at the jail. They'll let Miss Cole know, and so on and so on. Best of luck to you, sir. You got all that, Miss Holmes?
Yes, Judge.
You gonna text me when they're all in the queue, or are they all already there?
I know, she's funny.
I have 2 more to do. And I'll text you.
All right. You with us tonight, or is that
Go with this young woman right here. She's going to tell you what to do.
No, it's not me. I think it's Miss Rowe.
Oh,
I
okay.
think. Well, whoever it was Tuesday. Monday and Tuesday.
All right. Anything else we need to put on the record, or can we?
That concludes my business here for the day.
I believe that concludes ours as well.
All right, Madam Court Reporter, is there anything you needed, spelling of names, et cetera, et cetera?
Y'all are wonderful. Judge, you are wonderful to work for, and I've enjoyed it. Thank you.
Thank you so much. Such kind words. Thank you. I don't get many of those, but thank you. Yeah.
Judge, you should really read the comment section at Law Talk with Mike. You get plenty of kind words.
Ms. Holmes is always nice to you. All right. You guys have a good afternoon.
And don't forget to hit like and subscribe. Don't make Oscar beg. It's rude.
Thank you very much for the number. The interpreter is ready.
Thank you. You're in front of the Honorable J. Cedric Simpson out of the 14A District Court, Washtenaw County, State of Michigan. We need your assistance with one felony matter. Can you please raise your right hand to be sworn?
Certainly.
Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially using your best skill and judgment, and to translate from English into Spanish and from Spanish into English in the manner now before the court, so help you God?
Yes, I do.
Thank you.
Good morning. Good morning.
Good morning, sir. Yes, sir. Good morning.
Okay, so this is Attorney James Gallagher's final appearance in front of Judge Simpson. For those of you, a lot of people know this, but he's kind of he's one of the attorney favorites on the channel. He's just a good, earnest, hardworking guy that's very likable, and we have the court appearance. I leave it in for context, but really the big thing is the sweet send off that Judge gives him afterwards.
Let's call the case. People of the State of Michigan versus Louis D. Aponte.
Aisha Hill for the people.
El tribunal presenta el caso de la ciudad o el estado de Michigan en contra de Luis Díaz Padre.
I don't know if he caught you, Miss Lundy.
Ashley Londy for the people.
Thank you. Tenemos a la señorita Ashley Lundy representando al estado.
James Gallagher, Assistant Public Defender on behalf of Louis Aponte.
Representando legalmente al señor Luis Aponte, el señor James Gallagher como abogado defensor público.
What are we doing on this today?
¿Qué haremos el día de hoy con esto?
Your Honor, we have 2 requests, one regarding the probable cause conference and one regarding bond.
Su señoría, contamos con 2 peticiones o solicitudes el día de hoy, la primera de las cuales consiste en causa probable para este caso y la otra consiste en la fianza.
Regarding the probable cause conference, Mr. Aponte is requesting to have a in-person preliminary examination.
En lo que respecta a la reunión para la causa probable, el señor Aponte está solicitando que se lleve a cabo una interrogación preliminar, audiencia preliminar en persona.
All right. I will set in-person preliminary examination for January 3rd.
Oh, damn it.
En ese caso, go ahead, Your Honor, sorry.
Okay, I'm sorry. January 3rd, 2023, 9 a.m. before Judge Fresh Hour.
The interpreter does apologize for the interruption. Yeah. Bien, en este caso me dispongo a preparar o programar esta audiencia preliminar en persona para la fecha 3 de enero de 2023 a las 9 de la mañana, compareciendo ante el juez Fresh Hour.
Your other request, Mr. Gallagher?
Sí, su señoría le da la palabra al señor Gallagher.
Your Honor, regarding bond in this matter is currently $50,000 cash or surety.
¿Quién está asegurando al señor juez que se está solicitando la fianza? La fianza que se estipularía para este caso sería por la cantidad actualmente de $50,000, ya sea en efectivo o con una fianza, con una garantía.
Mr. Aponte is requesting a bond reduction with GPS tether for the court to consider.
El señor Aponte le pide al tribunal que tome en consideración la posibilidad de una reducción de la fianza a través de un dispositivo de GPS.
He was working in the construction business prior to being taken into custody.
Antes de ser detenido, el señor Aponte se encontraba trabajando en el sector de la construcción.
He can continue that work if he should be released and be able to provide for his children.
Él puede continuar trabajando todavía en dicho sector siempre y cuando sea puesto en libertad y poder mantener a sus hijos.
I do recognize that Mr. Aponte does have 3 pending matters at the 14B District Court with warrants, with bonds.
He podido localizar el hecho de que cuenta el señor Aponte ya con 3 casos pendientes en donde cuenta con fianzas a través del tribunal de 410B.
And he does have 1 pending misdemeanor matter before this court with a bond.
De hecho, también el señor Aponte cuenta con otro asunto por un delito menor que se encuentra pendiente en este tribunal con una fianza.
However, he is requesting a bond reduction in this matter.
Y sin embargo, el señor Aponte se encuentra solicitando la reducción de la fianza para este asunto, tratándose ahora.
Response.
¿Y la respuesta?
Your Honor, I don't hear any new information from the time that I was present at this defendant's arraignment when his original bond was set.
La respuesta es que no pude escuchar ninguna información nueva en la ocasión en la que yo me encontraba presente durante la lectura de cargos para este individuo cuando se estipuló la cantidad original de la fianza, comenta la señorita Lundy.
Looking only at the cases that Mr. Aponte has opened that involve the people involved in this case, we have a malicious destruction of building from August 2022.
Estamos viendo los casos que el señor Aponte tiene abiertos actualmente con las personas que están participando o involucradas en este caso. Entre otros, es uno de los casos constituye el caso de destrucción con agravante de una construcción, con fecha de el mes de agosto de 2022.
The victim in that case was Eva Alvarez Ronquillo.
La víctima en dicho caso era Eva Álvarez Ronquillo.
Then we have a case from September the 6th, 2022, where the victim was Ernesto Alvarez, an assault and battery.
Y también tenemos el caso del día 6 de septiembre de 2022, en donde la víctima lleva por nombre Ernesto Álvarez. Esto debido a una agresión física.
Then there's a case from October 30th, 2022, a domestic violence case, where Eva is the victim.
Y tenemos también otro caso en donde la señora Eva fue la víctima de un caso de violencia intrafamiliar con fecha del 30 de octubre de 2022.
Then we have the case at present before the court today, which involves Eva's 14-year-old child who was home without her being there when the defendant came over and tried to get into the house.
También cuenta con el caso presente en este tribunal actualmente, en donde se encontraba presente el hijo de la señora Eva,
Okay, the subtext here is this is James Gallagher's last court appearance in front of Judge Simpson. He would love to rule in his favor and throw him a bone about something, but this just isn't the case for it. And Ashley Landy's doing a great job and smothering that dream right now.
De 14 años de edad, quien se encontraba en casa con ella cuando el demandado trató de ingresar o entrar a dicha casa.
He tried to force the door open and used a hunting knife to break in, causing extensive damage to the door frame. Ava's son tried to push the door shut, but the defendant had his hand and arm inside and cut the child with the knife.
Aquí no hay ninguna nada, solo una tarjeta de ID.
And I would just ask that Mr. Aponte not make any statements.
Yes.
This is the interpreter. With all due respect, what Mr. Aponte interjected with is that wasn't a hunting knife. It was only a 5B card, ID card. Y se le pide al señor Aponte que por favor no presente en este momento ningún tipo de declaración. Is the interpreter allowed to translate the state's last statement?
Yes.
Thank you very much. El señor Aponte entonces trató de forzar la puerta abriéndola con un cuchillo, tratando de abrirla con un cuchillo de caza. Lo que provocó al tratar de abrir esta puerta fue un grave daño al marco que circunda o se encuentra al lado de dicha puerta, mientras que el hijo se encontraba por el otro lado tratando de empujarla y cerrar esa puerta para que no la abriera. Lo que sucedió es que el demandado con el cuchillo, sin embargo, terminó cortando con dicho cuchillo al hijo en esa actividad. Thank you.
Thank you.
There was also damage done to Eva's car tires as the defendant fled the scene that day. I am extremely concerned that if he is released, the violence will continue to escalate. So I'm asking the court to keep the bond where it is.
El daño también continuó a través de las llantas del carro de la señora Eva, mientras el demandado se retiraba huyendo del lugar de los hechos ese mismo día, dañando dichas llantas. A mí me inquieta, me preocupa sobremanera que este acto de violencia va a seguir incrementándose, llevándolo a un nivel superior de violencia, y es por ese motivo que me encuentro solicitando ante este tribunal y a esta su autoridad que se permita que la fianza quede estipulada en esta cantidad que tiene ahorita.
Anything else, Mr. Gallagher?
¿Algo más, señor Gallagher?
Judge, nothing other than what the court already knows, that Mr. Aponte denies the allegations.
Señor juez, no hay nada más que declarar, únicamente lo que ya sabe el tribunal, que el señor Aponte se encuentra negando dichas declaraciones.
Motion for bond reduction is denied. Bond will continue.
La petición o solicitud para la reducción de la cantidad de la fianza ha sido negada. La multa continúa vigente.
It's about to get all sweet in here.
Thank you, Mr. Interpreter.
GPS.
Would that be all for the interpreter today, Your Honor?
Yes, it will. Thank you
very much for your services. Have a nice day.
Thank you.
Yes, sir.
And Mr. Gallagher, if you could please remain on the screen there. I know that's your last case. The only case.
It is.
The court is Madam Recorder, if we just go on a separate record. This is, I know the last time I think that you'll appear before me. You've been appearing before me for a number of years. Appeared before me as an intern. That doesn't say anything about how old I am. And I want to say from the start, for those that don't know, you will be going to be the judicial attorney for the Honorable Judge Slay, newly elected new judge in this county. I frankly spoke with her last night. She gave me a call to offer my condolences. She thought yesterday was your last day before me. She was apologizing for taking you from us. But I will tell you that I think that you, as I've expressed to you, I think that you're going to do a great job. It's well deserved that you've done that throughout your career. From this judge's perspective, you exemplified yourself with the highest standards of those practicing who have the privilege to practice in this state as lawyers. More so, you've exemplified yourself in a manner as a public defender that has just been extraordinary. The way you deal with people, the way you deal with the courts, the integrity, your humility, your intellect, and everything that you brought to it always made it a pleasure to have you appear before the court. I know that you don't like these things being said about you. I know that it kind of, it gets at you. You try not to take a lot of credit for things. But I think over the years, if you would talk to those individuals that you've represented and have helped out, to, I think, any member of the bar, I don't care what side they're on, whether it's prosecutor side, defense side, you can find no one who will ever have anything bad to say about Mr. Gallagher. And I would indicate also to you, as I expressed to Judge Slay, that I don't believe, while I'm upset that you won't be here before me, I also do know that she could not have made a better choice for somebody to be by her side as she begins that new part. So, Mr. Gallagher, on behalf of this judge, my staff, Tang, Ms. Weidling, Mr. Allen, we want to thank you for the recent time that you've been here before the court. You've made it, you've made it fun in a lot of ways. You've helped a whole lot of folks just in the brief time that you've been here. And if I dare say that I speak on behalf of our whole court and also the people of Washtenaw County, I know that you will continue to serve Washtenaw County. But on behalf of all of us, we thank you very much for your service. You did an extraordinary job. Godspeed, my friend, and I wish you all of the best in a new chapter in your life.
Judge, I can't thank you enough. I have some tears here, Judge, but
Aw. That's pretty sweet.
I probably won't be able to talk here a whole lot, Judge, but thank you. I see my fellow bar members here, and you're right, Judge, regardless of the side that we're on, I have nothing but respect for everyone here. I see the public defense management team and my colleagues at the public defender's office, people who I truly love and care for. They've been tremendous for me. Also, prosecuting attorneys, nothing but respect for all of you. I think we've worked well together and developed good working relationships along with friendships, and can't thank you enough. The court, Judge, I can't say enough. I feel like I've grown up in front of you. I was an intern. You've seen my kids grow, and they're adults now. And you've helped me become a better attorney, Judge, just watching you and watching you on the bench and challenging me with the you made it tough at times, Judge, but you made me think, and but you truly made me a better attorney. And it's been an honor and a privilege to practice in front of you over these years. And you've seen me grown as an attorney, and I've learned so much from you, and just can't thank you enough. And I've learned so much from all the attorneys online here. You said that I brought some intellect. I'm not so sure about that, but I tried my best, and I tried to learn from the intellect of everyone that's on Zoom here from my fellow attorneys. But thanks again, Judge. I'll be working behind the scenes more. I won't be representing folks, but I also want to just thank the clients that I've represented and allowed me to give me that privilege. I tried my best for every one of them. I know not all of them were probably happy with me, but I did try my best for every one of them. But thank you, Judge. I probably shouldn't talk anymore, Judge. I've got some tears in my eyes here.
All right. Thank you, Jim, for those comments. Madam Recorder, if you would please prepare a transcript of the court's comments as well as Mr. Gallagher's remarks, and we will send you a copy of those as well as a copy of the visual of this. Jim, take care of yourself, my friend.
Thank you, Judge. Thank you, everyone.
End of the separate record. All right. Give me just 1 second.
Well, there you have it. I thought that was pretty sweet. That's one of the neat things when I started doing this channel, and you're showing court things. People were really surprised that the way people interacted in court. And I've seen situations like this many times. Judge Simpson's really cool, but I know a lot of cool judges, and you see a lot of people who go on in their career. It also happens in law firms. It happens in every industry and all that. But this is not that strange. If you have a bailiff or an attorney moving on, that's practiced before a judge for a while, that they'll take some time out and make a big fuss out of it. And, those sorts of things surprise people. When I first did this channel, I'm like, what do you think? We just hit each other with sticks all the time? Well, we do. But occasionally we pause and say nice things too. It really does. And that's not even that rare. It doesn't happen every day, but I've seen a lot of judges do this sort of thing with their clerk, with an attorney that's always before them, with the prosecutor, with the public defender, with the bailiff, whatever. I've seen Judge Simpson do it, but I've seen this. I've sat in court and watched similar things unfold. It's always touching and sweet, and it was in this case. Gallagher got to us. It's because of the headphones. I remember Rob making fun of him like the first time I did a video. This is like a few months ago. It sounds like I'm doing 20 years of reminiscing here. And it just sort of made him stick out even more in my mind. But he's just a good, competent guy, just trying to do the right thing for his client. Right there, it was cool too. In this particular case, his last hearing, he asked for a bond reduction for this guy. Well, that guy ain't getting a bond reduction. Judge Simpson knew he was going to give him this big send off, and he's very fond of him. They've known each other a long time. Obviously, this was heartfelt, but he's like, but that guy's not getting his bond reduced. I mean, we're not, this is business is business and personal is personal, but, and Attorney Gallagher knew it. He just is a pro and did what needed to be done for that client. He's a public defender. That's his role for that appearance. And he's got to ask for a bond reduction. He's not getting it, but he's got to ask for it. So I thought that was all touching. So there you go. I had Judge Simpson rip your heart out with that sweet little speech. And but prior to that, I delivered. I had Judge Manning singing Outcast. And then I felt obligated. By the way, I think she may still be going. Yeah, she had a night call too. She was going as I started this stream. But then I felt obligated to show a bunch of that call to show the amount of work and attention and effort. She's not just sitting around singing Outcast. That's like 10 seconds of hours of work. So anyway, that was kind of a fun one. Thank you all for coming out. I'll see you all soon.